Good morning, folks. I'm attorney Roger P. Foley, driving to court early this morning for a bond revocation hearing. Well, actually an arraignment in bond status because they've added additional charges to a client's case. So normally you go to an arraignment, or you usually don't go to an arraignment. If you don't have an attorney, you go to an arraignment and you plead not guilty. When you hire a private attorney, we do pleadings on your behalf and we file in as not guilty, and the arraignment usually gets deleted. The only time the arraignment does not get deleted, right, is when they add charges or change charges. Even if the wording is slightly different, they have an arraignment and bond status, which is just the court's way of letting the defendant know that the charges have been changed in some manner. And it also alerts the bondsman because there needs to be a determination whether the bond is increasing, decreasing, staying the same, or if the individual is going to be ROR'd on it. But I'm not here to just talk about arraignments. I really want to talk about bond revocation. If you're charged with a crime and you're placed on any sort of pretrial conditions, whether that be pretrial release, SOR, some form of bond. Normally, most folks pay, a cash bond, or they hire a bondsman. If while you're out on bond, you violate the conditions of your bond, and here's the perfect example. If you're charged with a new crime while you're out on bond, there's no adversarial hearing. There's no per se notice requirement. The judge can simply on its own motion, the court on its own motion can say, okay, we're going to do a bond hearing right now. Or he can just simply say, without the hearing, because I find probable cause that you've been arrested for a new charge, I find probable cause of that. So here's where it's interesting, folks, and here's where it's different, all right? Normally, on a motion to suppress, for instance, there's what's called hearsay. We've all heard this on television, hearsay, where you don't have an opportunity. Someone's saying something or a document is saying something, but there's not an opportunity to be cross-examined, right? Well, what the court has found, and it's amazing to me that the court has found this, is that if an individual who's on bond has been arrested, the probable cause affidavit on the new charge is sufficient, even though as a defense attorney, I can't cross-examine a piece of paper. If a police officer writes it, it's considered sufficient and the bond is revoked. There's nothing you can do. The same standards that are applicable in whatever section it is, 3.13, where it has to be, everyone's entitled to bail unless it's a capital charge, and everyone's entitled to a reasonable bond, per the 8th Amendment. Those factors that the court normally considers, like what's the risk factor? For instance, if you get charged with burglary, first time, no history, the court has to make a determination. Okay, how do we keep the place safe, right? How do we keep the community safe? And how do we guarantee that the defendant will show up? Well, that's not too hard, and that would be a bond probably $1,000 to $5,000. However, if you now get a driving while license suspended, or another burglary, or a marijuana charge, well, guess what? That same analysis of what do we need to do to get the defendant, to ensure the defendant's presence at trial, and what do we need to do to keep the community safe, that's no longer the standard. The standard appears to be, if there's probable cause of a new crime, the state attorney, the prosecutor, on its motion, can file for the bond to be revoked, And what that means is the defendant will stay in custody on the first case until it's resolved, either through a plea or through a motion or through trial. That puts a lot of pressure on the defendant, because let's say a defendant has 2 charges. Well, he's going to sit in custody. But here's the part that bothers me the most, folks, is what if you have the same police officer or the same agency, police department, and they make what many might consider a bogus arrest of the same individual. They've already arrested the individual once and he's out on bond, but what if they target him? What if they pay special attention to him? What if they go out of their way to figure out how to get a charge? And you go, what? In South Florida? Would police consider such a thing? Look, I can't read another man's mind. I can only read and interpret what I see on documents, folks. So is it possible that a police officer or a police department will do anything to get their guy, right? You've seen The Shield, right? You've watched Law and Order. You see how police officers go, hey, we'll beat you, we'll do this. Where is the story writers getting the information? Are they basing it on real events, although it says on Law and Order that they're not? So is it possible that a police officer wants to ensure that the individual is in jail, and maybe he trumps up charges? It's possible. I'm not saying, folks, listen, I'm not a huge fan of police. I'm not a fan of police, right? However, I'm not a naysayer. I'm not saying that every time a police officer files a report that it's bogus or BS. I'm not saying that. But I'm saying, can it happen? Does it happen? In my opinion, yes and yes. Do I think that officers plant drugs on people every day and set them up for crimes they didn't commit? No, I don't believe that. Do I believe that they exaggerate and that sometimes the adrenaline is part of the chase, a part of the capture, a part of, their team versus the other team? Do they get a little carried away? They do. So what happens if you're out on a charge, right? Out on bond, and you have an overzealous police officer or police department and his buddies come in and make another arrest? Even though the arrest isn't so great, you'll have your opportunity to fight that, but that automatically, right, gives the court the power to revoke your first bond and sit your butt in a jail cell. You sit in custody waiting for the first case. So think about that. You're charged with burglary as a hypothetical. And let's say you get pulled over and you're not pulled over. Let's say you get charged with trespassing. Like that you're sitting in front of 7-Eleven and you're smoking a cigarette, or you're hanging out and talking to your fellas, and an officer charges you with trespassing or loitering. Guess what? That new charge violates the conditions of your original bond, and you, my friend, will sit in custody. Is that fair? Did the Supreme Court think about that? I can't tell you. I wasn't there. But these are the problems that exist on this side of the aisle, folks. So I'm attorney Roger P. Foley, talking about bond revocation. If you're out on bond on any charge, be perfect. Be as close to perfect as possible. Do not give police a reason to charge you with a subsequent charge, because you may very well end up in custody.